Republic Act 7877, Anti-Sexual Harassment Act of 1995. Section 1. An act declaring sexual harassment unlawful in the employment, education, or training environment and for other purposes. Section 2. Declaration of Policy. The state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Section 3. Work, education, or training-related sexual harassment. Work-related sexual harassment. The sexual favor is made as a condition in the hiring or in the employment, reemployment, or continued employment of said individual, or in granting said individual favorable compensation, terms of conditions, promotions, or privileges, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. The above acts would impair the employee's rights or privileges under existing labor laws. The above acts would result in an intimidating, hostile, or offensive employment for the employee. Education or training related sexual harassment against one who is under the care, custody, or supervision of the offender. Against one those education, training, apprenticeship, or tutorship is entrusted to the offender. When the sexual favor is made a condition to the giving of a passing grade or the granting of honors and scholarships or the payment of a stipend, allowance, or other benefits, privileges, or consideration. When the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission thereof by another without which it would not have been committed, shall also be held liable under this act. Section 4. Duties of the employer. Promulgate appropriate rules and regulation in consultation with and jointly approved by the employees or students or trainees through their duly designated representatives, prescribing the procedure for the investigation of sexual harassment cases and the administrative sanctions. Therefore, administrative sanction shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. Create a committee on decorum and investigation of of cases on sexual harassment, the committee shall conduct meetings as the case may be with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases constituting sexual harassment. Section 5. Liabilities. The employer or head of office, educational or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education or training environment in the employer or head of office, educational or training institution is informed of such acts by the offended party and no immediate action is taken. Section 6. Independent action for damages. Nothing in this act shall preclude the victim of work, education or training related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Section 7. Penalties. Any person who violates the provision of this act shall upon conviction be penalized by imprisonment of not less than 1 month nor more than 6 months or a fine of not less than 10,000 pesos nor more than 20,000 pesos or both such fine and imprisonment at the discretion of the court. Any action arising from the violation of the provision of this act shall prescribe in the 3 years. Section 8. Separability clause. If any portion or provision of this act is declared void or unconstitutional, the remaining portions or provisions thereof shall not be affected by such declaration. Section 9. Repealing clause. All laws, decrees, orders, rules, and regulations, and other issuance or parts thereof inconsistent with the provision of this act are hereby repealed or modified accordingly. Section 10. Effectivity clause. This act shall take effect 15 days after its complete publication in at least 2 national newspapers of general circulation. That's all. Thank you.